Hi guys, welcome to Kanavilim Karpo. In this video, we are going to discuss company law under chapter 2, incorporation to introduction of company. After introduction of company, it means after incorporation of a company got a separate legal entity, a company got a perpetual successions for lawful purpose. Okay. Who initiate the company? The promoters initiate the company. So, what is the meaning of promoters? Promoter means who has been named in the prospectus or is identified by the company in the annual return referred to in section 92. Who has control over the affairs of the company, whether directly or indirectly, whether as a shareholder or director or otherwise. Whose advice, directions, or instructions of the board of directors of the company is accustomed to act. Okay. However, a person merely acting in a professional capacity shall not be treated as a promoter. For example, solicitor, accountant, banker, they are not called as a promoters. They are acting merely professional capacity persons. Okay, next section is section 3, formation of company. Formation of company means in case of public company, seven or more persons. In case of two or more persons, it's called a private company. Only one person is called a one person company. So this is called as a formation of company as per section 3 of the Companies Act 2013. Next section is section 3A. Section 3A means members are severally liable in some of certain cases. Okay. In this section, when the company, if any time the number of members is reduced, in case of public company below 7 or in case of private company below 2, the company carries on business more than 6 months, then the remaining members shall be liable for the whole debt of the company, or they will be liable unlimited liability, or they will be sued. Next section is incorporation of company as per section 7 of the Companies Act 2013. In this section, after incorporating the company, the following points should be considered. First one, reservation of name by filing e-application. Second one, signing of MOA and AOA. Third one, signing the documents and register with the registrar. Fourth one, consent of persons nominated as director to act as directed to submitted electronically. Next one, submission of statutory declaration of complaints and other declarations. Next point, pay fees and amount of stamp duty electronically. Next point, obtain certificate of incorporation digitally signed by ROC. Then last point, file declarations about the registration of ROC. Last point, file declarations about address of registered office. Next section is subsidiary company as per section 2 subsection 87 of the Companies Act 2013. Subsidiary company means a company which is a holding company, controls the composition of board of directors, controls more than one half of the total voting power, or should be treated as a deemed company. Next section is section 2 subsection 62 of the Companies Act 2013, one person company. One person company means only one member in the company, private company in nature, separate legal entity, limited liability, encourages entrepreneurship and corporatization of business, procedural requirements of simplified through exemptions. Miscellaneous points in one person company. One person company cannot be converted into section 8 company. One person company cannot do two things. First one cannot invest in the non-banking financial companies. Second one cannot invest in the body corporate. One person company can be converted into private company or public company as its discretion. One person company cannot buy off another company. Minor cannot be nominee or member of one person company. Who can incorporate one person company? A natural person, Indian citizens, and a resident of India who stayed in India in the previous year, 120 days in the previous year itself, shall be eligible to form one person company and to become nominee. Next section is Section 8 company, that is formation of company charitable object as per the Companies Act 2013, that is not for profit organizations. Section 8 company means object to promote commerce, arts, science, sports, social welfare, education, research, charity, and protection of environment. Under Section 8 companies, earning the profits and would be used only for its promoting the object only, not for any other purposes. Under Section 8 company, providing dividend is restricted. So, Section 8 company cannot be provided dividend. Okay. Other provisions. In case of Section 8 company, the central government can issue license to formation of the company. In case of Section 8 company, a company do a or a company make a contravention or violation of the object of the company, then the central government can have the rights to revoke the license. Before revoking the license of the company, the central government may give opportunity of being heard of the company. If the company proved that the statement was immaterial, then the license cannot be revoked. If the company is not proved that the statement was immaterial, then the company license can be revoked by the central government. Okay. After revocation of the license of the company, the central government can be do three things. First one, a company can be amalgamate with similar object of the company, or a company may be wind up and the assets may be sold out and settle the creditors and do other things, or a company may be merged with any other similar business of Section 8 company. Okay. Miscellaneous points in Section 8 company. Normally, general meetings, that is 14 days notice for general meeting under Section 8 companies. Requirement of minimum directors or independent directors are not applied. Next point, need not constitute nominations and relationship committee, stakeholder relationship committee. Okay. In case of Section 8 companies violating the object of the company may be punishable. Fraud under Section 447. A company involved here or contravenes the object of the company, then the fine may be 10 lakh to 1 crore rupees. In case of default in officer or employee of the company, a fine may be 25,000 to 25 lakhs. Next section is effect of registration under Section 9 of the Companies Act 2013. Once the company is registered, the company is having a perpetual succession. The company is having the separate legal entity. The company is distinct from its members. Okay. After registration, the company to sue and be sued in its name. Okay. Next point. After registration of the company can hold or dispose of property. Okay. Next section, Memorandum of Association under Section 4 of the Companies Act 2013. Memorandum of Association means is a document of a company. It has 6 classes in the MOA. First one, name class. Second one, subscription class. Third one, liability class. Fourth one, registered office class. Fifth one, object class. Sixth one, capital class. Okay. Next section is doctrine of ultravirus. Okay. Doctrine of ultravirus means company. It means safeguard the company's creditors and investors. It is void and hence not enforceable. It cannot be ratified. Okay. Doctrine of ultravirus concept says forbids the company using money from the investors who are not listed in the memorandum's object class. That's it. Next one. Doctrine of constructive notice. It means if a person fails to read the public documents, a company assumes he is aware of it. It protects the company against outsiders. That's it. Next one. Articles of Association. Section 5 of the Companies Act 2013. Articles of Association means internal document of the company. Articles of Association contains rules and regulations of the company. Okay. The provisions of entrenchment. It means entrenchment means change in case of any change in the articles of association. For example, in case of public company, any change in the articles of association, the company should agree 75% of shareholders special resolution passed. In case of private company, any change in the articles of association, all members should agree, then only the company can change or alter the articles of association. Okay. What is the meaning of provisions of entrenchment? We already discussed entrenchment means change. The provisions of entrenchment means a company making the law more stricter to the company by its articles. It's called provisions of entrenchment. Next one is doctrine of indoor management. Doctrine of indoor management means is opposite to the role of doctrine of constructive notice, whereas the doctrine of constructive notice protects the company against outsiders. The doctrine of indoor management protects against actions of a company. That's it. What are the exceptions to the doctrine of indoor management? Otherwise, applicability of doctrine of constructive notice. Okay. First point, knowledge of irregularity. Second point, forgery. Third point, negligence. That's it. Okay, guys. The remaining sections will be covered in the next video class. Thank you, guys. All the best to everyone.